Welcome to the Sacramento Injury Law Podcast.
Welcome to the Sacramento Injury Law Podcast. I'm Lisa Mosby, your host, and today we're joined by Brian Jacobsen from Aiken and Jacobsen. With decades of experience fighting for the injured across Northern California, Brian is here to let us know why some injury cases are worth far more than others in California. Brian, thank you so much for joining me today.
Sure. Happy to be here.
Brian, beyond the medical bills, what are the invisible factors that drive that massive difference between value or in value?
Yeah, the invisible factors are what we call general damages. And that's in a civil suit, there's non-monetary. The medical bills obviously fall under the monetary heading. But typically those would be covered by pain and suffering, the intangibles such as emotional distress, loss of enjoyment, disfigurement, if it's a case maybe like a dog bite case or something where scarring is involved. Those are the kind of things that are separate and apart from the medical bills, which are usually pretty straightforward. It's a number, you can come up with it fairly quickly and fairly easily. All the other stuff is, like I say, a little bit harder, takes a little more involvement to prove.
And then California's new insurance minimums are $30,000. How does a case's value hit a ceiling simply because of the other drivers' policy limits? And how do you look for extra pockets of insurance to go beyond that?
Sure. You're right. The minimum here is $30,000 now. A case hits that ceiling pretty quickly and pretty easily just based on the value. If it's a very significant injury or a serious injury, then it certainly could be worth more than $30,000. Unfortunately, the law only requires the at-fault driver to carry that minimum. In those cases, though, that doesn't mean it's the job is over. We're always looking for, in a case that exceeds that value, we're always looking for, was a person working as an agent? Is there a way to invoke an employer's policy in this? Is there some sort of public entity liability? And then also there's, if the person who was involved in the accident has what's called uninsured motorist coverage, their limits may be much higher than the $30,000, which always gives us an additional avenue to pursue.
And then how much does a victim's career impact the math in a personal injury claim settlement?
Quite a bit. A career path directly impacts the civil damages because that's going to determine your loss of wages, the benefits that may accompany any type of job that you have, or your future earning capacity. The compensation that a person receives for that type of a situation is based on their pre-injury earning potential versus their post-accident reality. Maybe like a hand surgeon, for instance, he may get more if his hands are damaged in the accident. It really depends on if you have some specialized skills and those are compromised because of the accident, then we're going to look very hard to try and prove that in a case to get some extra value on that case.
So, Brian, how do you handle a case where someone had a pre-existing condition that made their new injury much worse than it would have been for a healthy person?
Well, handling pre-existing injuries in civil cases just requires proving the accident aggravated or worsened the condition. The way we do it would be by utilizing medical testimony to distinguish between the old and the new injuries. There's also the eggshell plaintiff rule here in California, where if you're injured but you've already had a bad back, the defendant, so to speak, takes you as you are. So, we're still going to try and prove the full extent of the aggravation, but you as what they call an eggshell plaintiff may be a little more susceptible to injury than others. And again, to do that, to establish that it's based on what was your baseline health at the time of the accident. And again, that's through medical testimony. It could be through friends who know you that, hey, so-and-so was working very hard, didn't have a problem after the accident, couldn't lift anything because of his back pain or neck pain. Those are all areas that we would pursue to try and prove the pre-existing part And really what we're trying to do is diminish it as much as possible so that the person can recover as much as possible.
And I've heard the terms fault and no fault. We've all heard those terms before. Let's dive into that a little bit. If a case is worth, for example, $100,000, but the insurance company successfully argues that the victim was 20% at fault for the crash, how does that fault math work? And how do you fight to keep that percentage at zero?
Well, the fault math is pretty straightforward on that type of situation. 100,000, you just subtract 20%, and you come up with the insurance company is going to value that case at 80,000. And our job is always to do as much as we can to bring that fault number that the insurance company looks at down. So again, it's really a process of proving that you look at whatever the facts are from any type of an accident, and try and establish that those facts really don't play into the insurance company's belief that there's, like you said, 20% fault or any fault at all on the client.
And is there always fault established, or is it ever at zero fault? One person is completely at fault. I mean, it takes two to tango. Both parties were there. Give me more to go on with that.
Sure. So absolutely, we do our best to bring it down to zero, and I would say most of the time we're able to do that. For example, if you're rear-ended on the street, certainly you didn't have any fault. Yes, you were there, but the other person is 100% at fault for either not paying attention, probably looking at their phone, anything along those lines. That's going to be a 100% fault case. Where it comes up where it might make a difference is, let's say the insurance company argues, well, yes, we rear-ended you, but you weren't wearing your seatbelt. Well, again, that's a good example, except if you're not wearing your seatbelt, what did the not wearing the seatbelt actually cause? If you broke your arm, and whether you had a seatbelt on or not can be established through medical testimony that, hey, the seatbelt didn't matter one way or the other. You were going to break your arm because of how bad the accident was. Again, that's a way to bring that 20% or whatever they want to call it down to a zero, or certainly minimal number.
How do you quantify the loss of enjoyment of life, or make sure that the insurance company pays for the person, not just the procedure?
Sure. And again, we're kind of going back to the intangibles. That would be, loss of enjoyment of life. If there are certain activities that you could, or, you can't do anymore after the accident, those are all things that we're going to look at in trying to come up with a value for that. And it may be established in terms of how to do it is, again, we may talk to friends of, hey, this was my partner on the bowling team, or, we used to go out and do this activity. I'm on a soccer team or a baseball team or something along those lines. And from the accident, this person can no longer do those things. That's always through the testimony of others that we can establish that and prove that. And again, it really comes down to trying to put a value on, what is that worth to a person? And it can be done, daily, of what is it like per day to have to go through your life now after this accident versus what was it like before? And there's obviously a value to that when a person has to go through that.
We talked about laypersons and friends, maybe family. What kinds of medical experts do you use to prove the cost of healthcare that hasn't happened yet?
Sure. I mean, it can be anything from, we can get medical billing and coding experts who will look at the cost of the bill and whether it's reasonable and reasonable for the area that we're trying the case in, or dealing with the case in. We also look at what they call life care planners, which is a person who may look at your situation and say, over the years, you're going to need X amount of dollars to go toward physical therapy or home care or something along those lines. They're very specialized in what they do. Oftentimes they're nurses or physicians themselves, and they'll create a comprehensive plan for future medical needs and associated costs, particularly in personal injury or long-term disability cases. The other, we always look at healthcare economists and finance experts. They'll look at the market rates and hospital reimbursement structures, the cost utility of treatments. We can go to, come back to treating physicians. They can testify about, hey, I've seen this person over the years, and I know exactly how this is going to play out based on my experience. And this person's going to need 6 months every year of some type of therapy to get over the constant pain that they're still having. So it's a myriad of different experts, but we've got a pretty good stable of them in our practice of, who to go to and when.
I want to talk about some terms, legal terms that come up that maybe our audience isn't clear on. When does a case jump from compensatory to punitive? Let's define those. And then if the other driver was under the influence or drag racing, how does that bad behavior multiply the value of the victim's claim?
Certainly. What we're talking about is punitive, obviously. The compensatory is pretty straightforward. You're compensating for what the person has had to go through, and what the law wants you to do is try and get you back to normal, back to 100%. Never really happens, but that's certainly the goal that we try. Punitive is a step up from that. Punitive is punishment. I mean, that's really what it boils down to. And the example you use of a drunk driver is probably the number one thing we see all the time is that's a person who is just acting recklessly and without regard for another person's safety. And that's really the way you get punitive damages is if the defendant, the bad actor, so to speak, does something that is really just a willful disregard for the safety of others. And to prove it, we're going to look at a lot of things. We're going to look at the defendant's wealth. We're going to look at what is it going to take dollar-wise to punish this person so that this action never happens again. It can happen, drunk driving is certainly a big example that we see when we handle car cases. You'd see it also in situations where maybe fraud or misrepresentation has occurred. We don't see that much on what we do, but those would be other examples of a bad actor doing something that they really shouldn't do and they know better. Intentional acts are also another way to get punitive damages.
Thank you for that definition. Sometimes the legal terms get foggy for us that don't study the law on a regular day-to-day basis. It's been said that insurance companies have risk profiles on law firms. How much more is a case worth simply because the insurance company knows your firm is willing to go to trial?
Well, we don't really know because obviously the insurance company will never show us their analysis. But I believe it's a substantial factor in the way that they analyze a case. When you're going to pick your attorney, that's one of the first questions I tell any potential client is, you need to ask that. Are you willing to go to trial? And is the attorney willing to go to trial? Because if they're not, I can see, it would make common sense that an insurance company would say, we're never going to pay you the full value simply because you're not going to take it to the end. Again, in our practice, we go to trial. We've gone to trial. That's not something that is foreign to us. So, it probably doesn't affect our analysis from the insurance company standpoint, but it is certainly a factor out there.
And you mentioned that's the first question that you ask is, do they have trial experience? I want to wrap up this episode with maybe a few more of those questions. What should people ask of their attorney or potential attorney when they're in that interview consultation process?
Well, I think they have to ask all the questions that they want to ask, but I think some of the important ones are, do you get along with your attorney? Because again, this is what I tell everybody is, I don't care how simple the case is, it's still going to be several months that you're going to be dealing with your attorney. And in my case, I talk to my clients all the time. You want to find out, are they willing to return your calls? Are you going to deal with the attorney directly, or do you have to go through some intermediary, a paralegal, a secretary, where most people that I've found want to deal with me directly, and I'm happy to do that. But you need to know that going in so that you have as a client, you have your expectations set correctly. If you think you're going to be dealing with somebody and you never get to talk to them once you've started the case, you're probably going to be fairly frustrated. Those are I guess I would call them common sense questions, but it's like a relationship that you're going to have with your attorney, and you want to make sure that you get along with that attorney or, him or her. because it's going to take some time. You're going to have to go through treatment. You're going to have to go through a settlement process. And ultimately, you may have to go through trial, which can add years to the process.
Well said. Thank you so much for your insights today, Brian.
Sure. Happy to do it.
Folks, if you have questions about your own case or need expert advice following an accident, connect with Brian at aikenjacobsenlaw.com to schedule a consultation. Thank you so much for listening to the Sacramento Injury Law Podcast. If you found this episode helpful, please like, share, and comment to help others find the essential legal resources they may need. And we'll see you in the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.